This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a bad faith setup often results in just time and expense for both the plaintiff and the insurer involved. In Maryland, if policy limits are offered before trial or before the insured is exposed to an excess verdict, there can be no finding of bad faith. When a seriously injured person is injured by a person with a policy providing minimal limits, the plaintiff's lawyer will invariably attempt to set up the insurer for a bad faith case by making an early policy limits demand with a short period of time to respond and without sufficient evidence to allow the insurer to respond properly. In David Grant Orndorff v. Erie Insurance Exchange, the Court of Special Appeals of Maryland on November 21, 2022, dealt with a situation where Mr. Orndorff had been so seriously injured in an accident that he had a leg amputated as a result of the accident and sought to set up Erie Insurance, the other driver's insurer, to recover more than the minimal limits available. Mr. Orndorff was seriously injured when the motorcycle he was riding struck another vehicle attempting to make a left turn. The driver was insured by Erie Insurance Exchange under a policy with a liability coverage limit of $30,000. 5 months after the accident, Mr. Orndorff rejected Erie's offer of its insured's policy limits in full settlement of his claim against the insured because the time limit had expired. 2 years later, when Mr. Orndorff sued Erie for bad faith in failing to settle sooner, the Circuit Court for Prince George's County granted summary judgment to Erie. 2 days after the accident, on October 17, 2016, the driver of the other vehicle Erie's insured reported the accident to Erie. Erie then immediately assigned a claims adjuster who began a thorough investigation of the claim the next day. 1 week into the investigation, on October 25, 2016, the claims adjuster received a message from Mr. Orndorff's retained counsel requesting that all correspondence go to her. On November 3, 2016, the claims adjuster reviewed the accident report, which indicated that Erie's insured was cited for failing to yield right-of-way and that Mr. Orndorff had exceeded the speed limit and thereby contributed to the accident. The adjuster informed Orndorff's counsel that Erie has received the policy report, which indicates your client contributed to the accident by speeding. I would suggest he have his own insurance company handle if he has not done so already. I am trying to reach the witnesses to confirm our final liability decision, but as Maryland is a contributory negligence state, your client may be barred from recovery against our insured." Close quote. Maryland, unlike most states across the United States, has not adopted comparative negligence. If an injured person contributes to the accident, for example by speeding, he or she cannot recover anything because of his or her contributory negligence. So on November 8, 2016, 34 days after the accident, Orndorff demanded that Erie settle his claim for the full insurance policy or any and all insurance policies covering the insured for the accident. Mr. Orndorff, perhaps as part of his plan, did not supply any of the requested documents or description of his injuries that Erie said were necessary to determine liability and settle the claim. Orndorff indicated he would release Erie's insured from liability if Erie delivered a check no later than 5 p.m. Eastern Standard Time on December 8, 2016. On November 21, 2016, before the deadline, Erie denied Mr. Orndorff's claim because its investigation showed that Mr. Orndorff was speeding and contributed to the accident. Orndorff then filed a motor tort complaint on January 9, 2017 against Erie's insured in the Circuit Court for Prince George's County and later served Erie's insured. On January 30, 2017, Mr. Orndorff's counsel emailed the claims adjuster that all prior settlement offers were withdrawn and that its insured had been served. On March 17, Erie, through the attorney assigned to represent its insured in the motor tort suit, offered to settle Mr. Orndorff's claim for the full limit of the insured's policy. On April 26, 2017, having not heard from Mr. Orndorff, Erie reiterated the limits offer. Mr. Orndorff's motor trucks tort suit, having been bifurcated between liability and damages, resulted in a jury finding Erie's insured liable for Mr. Orndorff's injuries. Specifically, the jury found that Erie's insured was negligent and Mr. Orndorff was not contributory negligent. On October 27, 2017, Erie again offered its insured's policy limits to Mr. Orndorff's claim against Erie's insured, and he again refused the offer. Before the trial on damages, plaintiff's counsel notified the circuit court they had settled Mr. Orndorff's claim with the entry of a consent judgment against Erie's insured for $2,870,000, an assignment of the insured's claim against Erie, if any, to Mr. Orndorff, and Mr. Orndorff's promises, one, to forbear on collection efforts while the assigned claims against Erie were pending, and two, to file an order of satisfaction once litigation of the assigned claims, including appeals, were over. On October 15, 2019, Orndorff sued Erie, claiming Erie had acted in bad faith in refusing his November 2016 demand. On March 29, 2021, Erie filed a motion for summary judgment, arguing that it had acted in good faith, not bad, in attempting to negotiate a settlement of Mr. Orndorff's claim within its insured's policy's limit. Plaintiff asked the court to do something it was not willing to do, to allow the plaintiffs to control bad faith, in the sense that a plaintiff could go to the end with an insurance company. An insurance company could offer policy limits on the eve of trial, and in cases where they offered it at eve of trial, the plaintiff, under the circumstances, could reject it and go forward, get an excess judgment, and then come back, presumably on behalf of the insured, and say, hey, they didn't offer the policy limits before we got this judgment. The trial court did not find bad faith. It concluded there was no breach of contract by the insurance company to its insured. It offered its policy limits. It offered its policy limits well before any judgment was entered against Erie's insured, well before any trial occurred. So this matter could have been resolved at an earlier time by the plaintiff. The plaintiff elected not to accept the offer of the policy limits and chose to pursue its claim against Erie's insured. The insurance company should not be at the mercy of what the plaintiff wanted to do, and that was the decision of the Maryland court. Genuine disputes, in the court's opinion, can arise from predicate facts or from the inferences that may reasonably be drawn from those predicate facts. The motions court found that Mr. Orndorff made a demand on Erie to settle for its insured's policy limit in late October or November of 2016, a demand that Erie denied. The denial was not in bad faith because it was based on the information Erie had at the time. By March 17, 2017, Erie had gathered more information and had come around to the determination that its insured was liable. Erie offered its insured's policy limits and full settlement, but Orndorff refused to accept the offer. Once an insurer undertakes to defend its insured on a claim, the insurer's wrongful failure to settle the claim is a claim in tort, not contract. The possibility of liability in tort does not mean that an insurer must settle all claims against its insured. Indeed, an insurer does not have an absolute duty to settle a claim within policy limits, although it may not refuse to do so in bad faith. An insurer's decision to reject a settlement will be in good faith if the decision consists of an informed judgment based on honesty and diligence. The appellate court was aware of no case, and Mr. Orndorff cited none to the court, in which a jury was permitted to determine an insurer's good or bad faith in settling or not settling a claim, where, as in this case, the insurer offered its policy limits and full settlement prior to the insured being at risk of an excess judgment. Even if Erie could be said to have acted in bad faith by denying Mr. Orndorff's November 2016 demand, Erie's subsequent offer of policy limits before its insured faced the risk of an excess verdict meant that Erie did not act in bad faith in attempting to settle Mr. Orndorff's claim against Erie's insured. Ultimately, the circuit court did not err in granting summary judgment in favor of Erie. Erie's subsequent offer of its insured's policy limit, an offer made well before its insured faced the risk of an excess verdict, foreclosed any claim by Mr. Orndorff, the insured's assignee, that Erie had acted in bad faith. In my opinion, Erie had a good reason to deny the claim originally, because Maryland still follows contributory negligence rather than what most states have adopted, comparative negligence. Regardless, when it did further investigation, it offered its full policy limits multiple times, only to have the plaintiff turn the offers down and insist on going to trial on the tort claim, eventually making a deal with Erie's insured to a stipulated judgment in the amount of $2,870,000, a judgment it promised not to collect from the tortfeasor, Erie's insured, but only from his insurer. Mr. Orndorff eventually received the $30,000 limit, which he could have received years earlier, and cost Erie and Mr. Orndorff's counsel much to pursue and defend two lawsuits that did not need to be filed, and wasted the time of the trial and of the appellate courts in Maryland, because there was no reason why they should not have accepted the limits. If the Erie's insured had a great deal of assets, was a multimillionaire, then I can understand not accepting a policy limits offer. But other than that, if all the money that was available to Mr. Orndorff was that $30,000 limit, he should have taken it. And if he had underinsured motorist coverage on his motorcycle, he might have been able to collect on that as well. But the court just denied the claim. Sanctions should have been considered, in my opinion. If you found this video to be of interest to you or your friends and colleagues, please tell them about it so that they can subscribe to the video on YouTube or rumble.com, and to the blog, which is posted 5 days a week and has been done so for many years. In fact, there are over 550 of these videos on rumble.com alone. You might also want to consider my Substack publication and my locals community. Thank you for your attention.